Good morning, everyone, and welcome to this latest Russell-Cooke charity webinar, Charities Disposing of Land, What is Going to Change? My name is Andrew Small. I'm the partner and property lead in the charity and social business team at Russell-Cooke, and I'm joined today by my colleagues Claire Garbett and Catherine Flexer, and together the three of us spend the vast majority of our working time on charity property issues. So what we are looking at today is the changes to the regime that governs charities disposing of land that are being introduced by the new Charities Bill. So if we go on to the first slide, this sets out what we're going to cover. When we were sort of dividing up the topics, it was pointed out to me that it would be best for me to do this sort of historic bit in the setting the scene, as I'm sort of old enough to have lived and worked through a much greater proportion of it than Claire and Catherine. So I'm going to start off by just setting out a bit of the history of the law in this area and explaining how we've got to this point with the Charities Act 2022 now being law. So then Catherine primarily will lead on setting out the changes to the regime on disposals of land, and then Claire will pick up some of the other property related changes into the Act, and throughout we will try and, I mean, it's a bit speculative at the moment, we will try and give you some comment as well as news, and just give our thoughts on how much of a difference will the new Act how much of a difference will the new Act really make? In terms of the when will it change point, that's still a bit speculative, because whilst the bill has now completed all its stages through Parliament and is the Charities Act 2022, none of the substantive provisions have yet been brought into force. There are going to be a series of statutory instruments and commencement orders that bring the new provisions into force over the next few months, and there's materials on the web from the Charity Commission saying this will be a major focus of theirs over the next few months, is bringing the new provisions into force in a measured in a measured and gradual way, rather than having a big bang with everything happening at once. So moving on to the next slide then, and just setting out some of the history. Before 1992, most substantive land transactions, certainly those involving permanent endowment or functional land for charities, needed Charity Commission consent. And this was, so the law started to change in this area with the Charities Act 1992, but then it was updated almost immediately afterwards in 1993. And for many years, the relevant piece of law was Section 36 of the Charities Act 1993. And so what the 92 and 93 Acts did was to allow for the first time trustees to self-certify that they had acted properly whilst selling land. Before 1992, you had to get Charity Commission consent, albeit only for permanent endowment and functional land. What the 92 and 93 Act did was they extended the controls to all charity land, but then relaxed them to say that in the majority of cases, you didn't now need to go to the Charity Commission. You could self-certify that as trustees you had acted properly and obtained best value by going through a particular prescribed procedure. So going on to the next slide. So what was the procedure under the 93 Act? And indeed, it's substantially the same now under the 2011 Act, and will be over the next few weeks or months until the new Act is commenced. There's a requirement on the trustees to obtain a report from a RICS qualified surveyor, so it had to be a qualified surveyor, that the disposal was on the best terms that could reasonably be obtained. So that was the test. That was what the surveyor had to conclude, and that was the test that the trustees had to be satisfied that the particular transaction met. It often, it generally means the highest price, but it doesn't necessarily mean if there are other factors that can properly be taken into account. So that was what the trustees needed to obtain, that report from a RICS qualified surveyor. And then there was also there's the question of when did they have to obtain it by, And the absolute requirement as set out in the Act is that they need to consider it and approve it prior to exchange of contracts. So prior to entering into an agreement to dispose of land, or if there's no agreement, prior to entering into the disposal itself. The topics that the surveyor needs to cover, it's quite prescriptive. The details set out in a statutory instrument, the reference of which is on the slide. And if you look at that, and any surveyors listening who prepare these reports will know it's quite prescriptive. It's very detailed as to what needs to go in there. And one of the particular points that needs to be covered in a lot of detail is about advertising, because the surveyor needed to confirm that the disposal had been thoroughly advertised unless they concluded that it wasn't necessary or appropriate to do so. And one of the main issues is that this quite prescriptive, very detailed regime didn't fit well with a lot of transactions, particularly the advertising requirements. I mean, one I've sort of grappled with a lot of times over the years is an electricity substation lease. So it's clearly a disposal of land. You're granting a long lease to UK Power Networks or whoever for a substation as part of your development, but value and marketing is a complete red herring. It's completely irrelevant to this sort of transactions. There are other transactions. Surrenders of leases is another one where dealing with compliance with the Act is quite fiddly, where the machinery that you have to force every transaction through at the moment doesn't really fit for a lot of transactions. And that's one of the things that's intended to be one of the things that the new regime is intended to deal with to some extent. So moving on to the next slide. When I first started, which is I qualified in 2002, so I've been doing this for sort of the thick end of 20 years now. And certainly when I first started doing charity land transactions, as lawyers, we really didn't give the substance of compliance with the Act a huge amount of thought. We knew that there were various statements that needed to go into the documents to confirm that the Act had been complied with, but in terms of interrogating the client and interrogating their surveyors, it wasn't really something we did. It wasn't really something we prioritised. It wasn't really something we did a great deal of. That very much changed 2003, 2004, when the Bayumi case first came to prominence and was published in the law reports and picked up by the legal profession and the surveying profession. So this was a case that without going into the detail, that essentially concluded that if a charity entered into a contract to sell land without having properly complied with the Act, and as you will see, there is a lot of detail that needs to go in with it. So the possibility that even minor technical minor non-compliance could lead you to the conclusion that the contract was void or voidable, and therefore, it couldn't be enforced. It couldn't be enforced by a purchaser or indeed by the charity if a purchaser didn't want to, subsequently refuse to complete. And so since that case, certainly in my experience, there's been a lot more effort within the sector and within the professional, so both on the surveying side and the legal side, in making sure that the Act was properly complied with and that trustees did have a surveyor's report in the right format before they committed to the transaction. However, as I've said, there's always been a bit of a view that the rules were a bit too complex and a bit too expensive to comply with, and there has been a bit of, there has been quite a process to get to that, to get to where we are now of suggested and proposed reforms, which is set out on the next slide. So the first reforms to the current regime, so the process that got us to where we are today, was started by Lord Hodgson when, in about 2011-12, he conducted a 5-yearly review of the effectiveness of the 2006 Act, and there was a lot of input, particularly from larger charities and particularly from surveyors, that the qualified surveyors report regime as was too fiddly, too expensive, and added cost and administrative burden to transactions for no significant return. I've understood that point of view, particularly coming from the larger bits of the coming from the larger end of the sector, but having acted for a number of smaller clients doing one-off property transactions, the sort they hadn't done for 20 years and the charity wouldn't do for another 20, I had always found it very helpful to have this machinery there so I could point to it and say to clients who might want to cut a corner or two or might want to be persuaded by a third party that they didn't need to do this, say, no, this is an absolute legal requirement. You have to, you have to do this. So I'd always found it quite a useful tool. However, Hodgson seemed to absorb the representations that were made from the sort of the larger charities within the sector and from the surveying profession. And what he proposed in his report was very, very significant deregulation of the regime, reducing it to, a statement in the Act that the trustees needed to act properly and in accordance with their core legal duties when disposing of land, and that they should follow guidance that he proposed would be produced by the Charity Commission. And as I say, I always felt that proposal there was an element of throwing the baby out with the bathwater there, that the loss of the clear legislative regime I thought would cause significant risks in certain elements of the sector. And the Law Commission, who then looked at and responded to Hodgson as part of a much wider exercise of review of technical issues of charity law, largely reached the same conclusion. They rejected in the main Hodgson's approach and proposed a more incremental reform of what was already there, but keeping certain absolute requirements for what what charities had to do when disposing of land. What with one thing and another, in terms of parliamentary time, not much then happened after the Law Commission's report in 2017, but finally there was a government response in 2021 that largely endorsed the Law Commission's approach, and this has led to the new bill, which, because for a couple of reasons, because the Law Commission had already produced a draft bill, and because it was recognised as an administrative piece of legislation and not desperately politically controversial, the actual passage of the Act through the House has been streamlined to some extent. So it took it took a bit less than I was expecting it to, and it's now had royal assent and is in force, but the substantive provisions have not yet been commenced. So by way of scene setting, that is a bit of the history and the sort of the law in this area and how we've got to where we are now. And I'm now going to hand over to Catherine, who's going to take you through the changes that are being brought in.
Thanks, Andrew. So I'm going to outline the main changes to sections 117 to 121 of the existing Charities Act, which are the sections that really contain those key disposal restrictions that Andrew's already outlined. And just to clarify for everyone, by property disposal here, we're not just talking about a freehold sale. We're talking about, as Andrew's mentioned, the grant of leases, the surrender of leases, even things like the grant of an easement, so the grant of rights over land. The exception to that is just for leases of up to 7 years, there is a reduced procedure to comply with. So when we're talking about the grant of leases, for these purposes, assume that we're talking about a lease of over 7 years. So firstly, the new Act's going to clarify circumstances when these restrictions will apply. So it's clarifying that they'll only apply where a charity is disposing of land which it holds solely for its own benefit. So in the case of a corporate charity, that's going to just simply be land that the property owns outright. In the case of a trust, it will be the trustees hold the land for the benefit of a single charity. And that just means that where there's a situation, say under a will, where multiple charities or indeed some charities and some other beneficiaries all jointly hold land, these restrictions won't apply, because the charity trustees of that particular charity won't really be the decision makers in that circumstance. So it doesn't really make sense for them to be held to these duties, but there will of course be overriding duties of the relevant trustee in that type of case. Then moving on, there's under the existing legislation, there are various exemptions from the need to comply with the restrictions on disposals. And a few examples of this include disposals that are authorised by a court order, and that could be something like a compulsory purchase order, and certain grants of leases to beneficiaries. But one of the exemptions that is slightly changing is the existing exemption for disposals from charity to charity that are made not made with a view to obtaining the best price reasonably available. And that will be modified so that it can't apply where the disposal is classed as a social investment. Now, social investment is defined in the new Act as an investment that's carried out with a view to both directly furthering the charity's purposes and achieving a financial return for the charity. And what this essentially means is that if a charity is disposing of property to another charity, even if they're doing it at far below market value, if there can be this argument that a financial return is still a motivating factor within the transaction, even if it's not the sole motivating factor, arguably that would then count as a social investment, and that exemption wouldn't apply, which would mean that the rules, the restrictions do need to be followed, obtaining a surveyor's report, etc. And then finally, the new Act will clarify that disposals on behalf of a charity by a liquidator or administrator in the course of an insolvency, or a mortgagee where they've exercised their power of sale, the Charities Act restrictions won't apply in those situations, which I think we already knew anyway, but it wasn't explicitly set out in the legislation, so that's helpful there. Then a quick note on changes to the definition of connected persons within these sections. And the reason that's relevant is because a disposal to a connected person will always require charity commission consent. So you can't get around that by going through the process of obtaining a surveyor's report with anyone who comes within this definition of connected persons. And connected persons include, amongst other things, trustees of the charity and their direct relatives, and employees of the charity and their relatives as well. The new Act provides a slight exemption on the employees of the charity front. It says that they won't be a connected person where the disposal is the grant of a tenancy for a period of 1 year or less, which grants that employee the right to occupy a dwelling as a home. Now, this is likely to be useful where a charity wants to let some property to an employee, and that can be, something that's useful or beneficial in lots of different situations. But at the moment, there's this stumbling block that it would always technically require charity commission consent. There is currently a way around that if you're granting, if your employees, the role that they're carrying out requires them to live on the property, say they're a caretaker or a carer or something like that, then you can grant them what's called a service occupancy agreement, which is a license agreement. So it's not a tenancy, it's not a disposal of land. So that's in that case, it really requires the need to occupy the property to be inextricably linked with the employment. So in a lot of other cases, that won't be the case. So this offers charities some really useful flexibility there. But note that this only takes that category of transaction out of the connected persons regime. It doesn't take it out of the whole regime altogether. So you'd still then, in granting that tenancy agreement, have to comply with the Charities Act, with the other restrictions on disposals, albeit the lesser requirements for leases of under 7 years. So it's only really likely to help where you are letting to that employee at a market rent or close enough to it to be justified under those restrictions. And then just a quick note to say that trading subsidiaries are still connected persons under this legislation, and I'm just making that point because in previous drafts it was proposed that that trading subsidiaries would also be taken out of that definition, which would give charities more flexibility for granting leases to their trading subsidiaries without seeking charity commission consent. But in the end, it was felt that those types of transactions do still need an increased level of scrutiny, and so they will always still need charity commission consent. Then moving on to changes to the type of advice that's actually going to be required. As Andrew mentioned, at the moment, the requirements are very prescriptive, and the advice must be given by a RICS qualified surveyor. Now, the new Act will replace references to a qualified surveyor with references to a designated advisor, and it will include RICS qualified surveyors within the definition of designated advisor, but there'll also be the scope to add extra categories of advisor to that definition. And the two that are proposed at the moment are Fellows of the National Association of Estate Agents and Fellows of the Central Association of Agricultural Valuers. Now, this is really useful potentially because it gives charities the flexibility to consult more relevant advisors in certain situations. So obviously with agricultural land, the agricultural valuer is likely to be the one to go with. Equally, if you're selling quite a straightforward residential property, you might feel that the estate agent is the one to go with, and they could be cheaper than the surveyor as well. So it's also potentially going to help save a little bit of cost. But there obviously is a downside with giving charities this flexibility, because less experienced charities might struggle to work out who is the appropriate advisor here, and they might have heard that they can use their estate agent and sort of go with them without question, which might not always be the best idea. So we'll have to see how that pans out, and whether charities do take advantage of this or do kind of err on the side of caution and stick with the qualified surveyor. But either way, whoever you go with should always you should check that they have the relevant expertise in the type of land you're selling and the area, the geographical area in which you're selling it as well. And it really helps if they do have experience in advising charities. And there are now, some really good surveyors out there who do have that charity expertise, whereas these other categories of designated advisor will be sort of new to that space and need to potentially build that up. The new Act will also clarify that designated advisors can be trustees or employees of the charity. Clearly, they would still need to have one of those required qualifications, and they'd need to have all the other relevant expertise. But if you're lucky enough to have a surveyor or an estate agent on your board who can give the advice, then that's allowed. Although for a major high value transaction, you might still consider that it would be better to get somebody independent to give that advice, just so that there can be no argument that there's been any conflict of interest there. And the required content of the report that the designated advisor is going to need to give is going to be less prescriptive. So as Andrew mentioned, the current regulations set out a long list of what the qualified surveyor's report has to cover, and a lot of that's just not going to be relevant in a lot of situations, and it becomes a bit of a tick box exercise because the surveyor is just trying to cover everything that's on that list, and it's not necessarily directly relevant to what's being proposed. So under the new regulations, the report will simply have to cover the value of the relevant land and any steps that could be taken to enhance that value, whether and if so how the land should be marketed, and anything else that could be done to ensure the terms of the disposal are the best that can reasonably be obtained, and any other matters that the advisor believes should be brought to the trustee's attention. So it's quite vague, but with good experienced advisors, that should enable them to give more tailored advice to the specific transaction. Of course, we'll have to see how it pans out, because it could, the vague requirements could, for less experienced charities, end up meaning that the report's not covering things that they need to know, and things are missed and mistakes are made. So again, it could, there could be some slightly more negative consequences there, depending on the level of experience that we're talking about. And then finally, just changes to the requirements to advertise the disposal. So under the current legislation, there's an absolute requirement that you must follow your surveyor's advice in terms of advertising the land. So what this means is, if even if you've got a buyer lined up, you go to your surveyor to get the report because you need to comply with this legislation, and they say in their report you should have, or you should put this on the market for X number of months or weeks or whatever. The trustees are obliged to follow that. There's no discretion there, and the new Act basically just removes that requirement. So it will put the decision back into the hands of the trustees. And this is going to be really helpful in scenarios where advertising just isn't relevant. So Andrew mentioned the grant of a lease of an electricity substation. There's not going to be a wider market for that kind of transaction. So advertising doesn't make sense. And similar with the surrender of a lease, you can only surrender your lease to your landlord. So advertising just isn't going to be relevant there. But even in more standard sales, sometimes if you found a buyer, they've come along and it's really in the interest of the charity to sell quickly, then again there could just be a really good case for not actually taking the time to advertise for that kind of thing as well. In practice, of course, I mean, as I mentioned when just describing what the new reports will have to cover, the advisor will still have to say whether, and if so how, they would advise that the land be marketed. And if trustees are choosing not to follow that advice, they will obviously want to have good reasons for that, and to make sure that their decision making's all been well documented and well recorded for future reference. So now I'm going to hand over to Claire, who's got some observations on other areas of the new Act.
Yes, so some of these might be a bit esoteric, but it's more charities than might realise it may be affected by them. So the first point was about trust corporation status. So I've mentioned the scenarios where that might be relevant. Just to go through those. So designated land is land where you hold land under your constitution or trust deed, etc., subject to a stipulation that it must be positively used for the charitable purposes of the organisation. So, for example, accommodation for visually impaired people. So, yeah, that's what designated land is. Permanent endowment is where you are to hold the land itself as an investment and keep it held in that form, or if you were to sell it, you'd have to hold it as a designated fund, and you only use the income, i.e. the rental income, to spend on your charitable objectives. So basically the view is that where you hold either designated land or permanent endowment, or where you merge with another organisation which has narrower charitable objectives, then you don't hold those funds, buildings, etc., outright as part of your corporate property. Instead, you hold them on trust. And that can be an issue where you are a corporate organisation, because where you hold property on trust, for various legal and practical reasons, you can't hold it as a single entity. You have to have more than one trustee, unless you are a trust corporation. And the only way for a corporate entity to be a corporate charity to be a trust corporation was to be appointed by a charity commission scheme, which is a bit of a pain. You have to go to the charity commission, get appointed, etc. And one major advantage of being a charitable incorporated organisation, i.e. the new type of body that was set up specifically as a corporate legal vehicle for charities. Previously, only CIOs could automatically be trust corporations for the purposes of holding these kinds of things. Whereas now there's a new provision under the Act that says any corporate charity, so a charitable company limited by guarantee or a royal charter organisation, etc., they can all be trust corporations, which will save some time and money. Then also, when they were doing this review, apart from putting a lot of attention on the provisions about disposal, as Catherine's gone through, most of the other things that they were thinking about in the Act tended to focus on governance and not much on property. So one of the things they've possibly inadvertently or possibly deliberately done is removed a loophole that used to be quite useful. On leasehold transfers, so for example, when you were incorporating or merging with another organisation and you had a covenant in the lease saying you can't assign this lease without your landlord's consent, there were under the current provisions, which haven't yet been removed, if you were a charity with any level of assets and you were transferring those assets to a charitable incorporated organisation, then there was basically there appeared to be a loophole whereby if you did that, you wouldn't need to seek your landlord's consent. Basically, there was a provision saying that any transfer pursuant to those provisions wouldn't breach a covenant against alienation, i.e. a covenant against transferring your lease to another organisation. However, those have all gone now as part of some other changes that they made on the governance level. And I think possibly they didn't appreciate that there was this quite useful loophole from a property perspective. But anyway, that's gone. So it'll be more important when you're taking a lease to include something in the alienation provisions saying that you will be allowed to transfer the lease to a corporate entity with similar objectives, for example, so as to allow you to incorporate or merge without necessarily needing to seek the landlord's consent and pay lots of additional legal fees, because of course you end up having to pay their legal fees as well as your own if you have to seek their consent. And then the final point was a lot of our charities struggle in situations where either can't deal with their property or are having disputes relating to their property because there's uncertainty as to whether trustees have been validly appointed. And there is now a new power for the Commission, with the consent of the relevant person, to order that any defect in a person's appointment or election is to be ignored, and a valid election or appointment is to be treated as having been made, together with some provisions allowing the Commission to vest property in that person. That certainly won't deal with all the problems involving vesting of property. Mostly, in my experience, charities want to try and get rid of trustees rather than appoint them. But it may help in certain situations where it's not clear that someone's been properly appointed. And that was everything from me. I'll end the recording and then we can go on to the next slide.